So, ladies and gentlemen, my name is Marcin Wielec, and I am the director of the Institute of Justice in Warsaw. It's a great honor and a great pleasure to welcome all of you on behalf of the entire management of Institute of Justice at the International Scientific Conference entitled Religion Symbols in Public Sphere in the Legal Orders of Central and European Countries. In particular, I would like to welcome all the distinguished experts we will have the opportunity to hear today. I especially greet Professor Ede Szilagi, Director of the Institute of Comparative Law, Ferenc Madl in Budapest. This institute is our partner in running this project. I'm delighted that the conference will be held in such a large group of experts from as many countries, 6 countries: Hungary, Serbia, the Czech Republic, Slovakia, Croatia, and Poland, of course. So it is important because it will allow to show a wider spectrum of issues related to religious symbols. Therefore, it is so important that the consideration undertaken during today's event will be enriched with regulation present in the legal orders of Central and Eastern Europe countries. I wish all experts and guests fruitful debates, interesting speeches, and interesting final conclusions. So I give the floor in this moment in my deputy, Mr. Professor Paweł Sobczyk. Please continue the conference.
Dear Director Marcin Wielec, dear Director Ede Szilagi, dear speakers, dear special guests, dear ladies and gentlemen, thank you very much for welcoming and opening the conference. Thank you very much to Director Szilagi for the initiative of such interesting research. It is an honor and privilege for me to participate in such important and international project. Thank you very much for the adoption of my invitation to participate in the conference of 2 special guests, Professor Balázs Sanda, Judge of the Constitutional Court in Hungary, and Professor Marek Bielecki, President of Polish Association of Law on Religion. Thank you also for Professor Piotr Stanisz that we wanted to act to the chairman of the session. The main organizers of the event are the Ferenc Madl Institute of Comparative Law, with cooperation the Institute of Justice in Warsaw and the Central European Association for Comparative Law. Our international conference, Religious Symbols in Public Sphere in the Legal Orders of Central and European countries, is one of the events of the research group Freedom of Conscience and Religion in Europe. I'd like to thank the professors, members of our rich team, for the cooperation so far within the team. Dear colleagues, thank you very much. Let me say a few words about the concept of this conference. The discussion about the presence of religious symbols has been going on in European realities for several decades. It's often marked by enormous emotional intensity, reflecting the attitude of society to the basis values on which Europe, culture, and civilization are based. And it also testifies to the Christian identity of nation. The main assumption of this analysis is to show the normative aspect in selected European countries relating to the possibility of manifesting one's beliefs through religious symbols. The position of the judiciary, expressed both by international bodies and by national judicial system, plays a fundamental role in shaping the contemporary model. It should also be emphasized that historical conditions also have an impact on the presence of religious symbols in public space. The conducive research will show the right of believers to manifest their religious feelings in public space while respecting the separateness and tolerance of people with different views. Today, at the international conference, team members will present some of their research results. So I wish you all fruitful deliberations. Now, I'm asking for Professor Piotr Stanisz, Head of Department of Law on Religion in Faculty of Law, Canon Law and Administration in the John Paul II Catholic University in Lublin, to lead the session. Dear Professor, please.
Thank you very much, Professor Sobczyk, and good morning, everyone. Let me start with expressing my gratitude for the invitation to act as a moderator during the first part of today's conference. Let me also congratulate the organizers on the initiative to undertake comparative research on the topic of religious symbols in public sphere in the legal order of the countries of our part of Europe. On the one hand, I'm deeply convinced that the chosen issue is still topical and important for the European Union, which can't avoid questions about its identity. On the other hand, I also believe that the important part of our societies, that is, the societies of the states which had similar experiences in the decades of Soviet domination, are characterized by a kind of common sensitivity as for their own culture and its religious components. So I'm very excited about the lectures we are going to listen to. The introductory lecture will be delivered by Professor Balázs Sanda. He is a professor at Pázmány Péter Catholic University in Budapest. He graduated from the Faculty of Law of Eötvös Loránd University in 1993. He obtained his PhD in 2003, habilitated in 2010, and was granted full professorship in 2012. During his career, he has held a number of important positions. Between 1999 and 2002, he was head of the Department of Church Information and Coordination and the Ministry of National Cultural Heritage. Between 2007 and 2013, he was a dean at the Pázmány Péter Catholic University. He has been a long-standing member of the European Consortium for Church and State Research, where he also served as the chairman. And since 2016, he has been a judge of the Hungarian Constitutional Court. Professor Sanda is the author of numerous publications on different aspects of religious freedom and church-state relations, as well as constitutional law. Let me mention his monograph, Religion and Law in Hungary, whose second edition was published in 2015 by Kluwer Law International. His today's talk is called Religion or Culture, the Protection of the Cultural Identity versus State Neutrality and the Lack of Faith. Balázs, the floor is all yours.
Thank you, Professor Stanisz. Maybe those present in the meeting don't know that we know each other for quite some time, and I think we can say that we are good friends. I'm trying to share my screen for a moment. I wonder if it will work. Do you see a picture in your screen? I would need some kind of feedback. Does anyone recognize the person in the picture? Little game. A lady with some roses, a castle in the background. Does the picture has any kind of suggestion, impression for you? It is a painting painted in the 30s by a Hungarian painter. He was, in fact, a Protestant himself, and he painted this picture under the title Saint Elizabeth of Hungary. Saint Elizabeth, the Miracle of Roses, is, I think, a very well-known story. Elizabeth is a very popular name in Hungary. You must have at least an aunt who is called Elizabeth. If not, then a cousin of your aunt. If even not, then your grandmother has to be Elizabeth. It's one of the most popular first names, which is second name, certainly in Hungarian. It's one of the most popular first names in Hungary. A few years ago, this picture turned up at an auction under the title Art Deco Lady with Flowers. It will sell for more than 20,000 euros, so it is regarded as a, well, I think I couldn't paint a picture that could be sold for 20,000 euros. She is a very popular saint, and actually for arts, the 20s, 30s have a good market nowadays in Hungary. But still, what could be the reason that the painting sometime has lost its original title? A few years ago, just a few weeks before Christmas, so in Advent time, I had a train ride from Stuttgart to Strasbourg. Probably you all know that it's not so easy to fly, to get a decent flight to Strasbourg, but to Stuttgart there are low-cost flights. So I took a flight to Stuttgart and then a short train ride to Strasbourg. On the railway station of Stuttgart, there was a huge Christmas tree. And under the Christmas tree, all the important figures of the nativity scene, full-size carved wood, wonderful statues, donkey and ox, and everyone who is necessary for a nativity scene. Also on the railway station of Strasbourg, there was a Christmas tree, a small one, but still a Christmas tree. And under the Christmas tree, there were dwarfs, Smurfs. Well, people still knew that, well, it's Christmas time, shopping season, or something like that. And something cute has to be put under the tree, but no word, no sign of the original meaning. Well, what is a constitution for? A constitution is a place of memory. If we still have a consensus on certain values, on certain, we share certain values, but maybe we feel that these values are endangered, then it could be reasonable to put them down before we forget it. Well, Saint Elizabeth, a very important saint for for Hungarian history in the 1200s, Hungary was, I think, quite successful in exporting princesses. I saw here on the list that one of the participants is a Kinga, Jolanta, or we could give a longer list of princesses who were married, for example, to the royal house of Poland, but to other royal courts as well. If you open the Constitution of Hungary, the fundamental law or the basic law, there are two different possible translations of the Constitution. Then the very first sentence may need some kind of explanation for a foreigner. The very first sentence is God bless the Hungarians. There are no quotation marks. It's even before the preamble. It's a kind of a motto. But even without quotation marks, all Hungarians know that this is the first sentence of our national anthem. That is a poem from 1823, well, almost 200 years old. And of course, the national anthem is a prayer that is sung at church events at the end of the mass or other major events. But it's also sung in a football stadium. And for some people, it has just a simple meaning of unity. That's not a simple meaning in itself even, but for other people, it may have an additional meaning, an added meaning. For other people, it's a prayer. But it is a document, it's a text that is uniting, I think, all Hungarians, and not excluding those who are non-believers or non-Christian. When you begin to read the text, we have a very long preamble, but also the preamble of the Constitution of Poland is quite long, but ours is, I think, still a bit longer. The previous constitution had a very short preamble. This new one has a fairly long one. Then at the very beginning, it has two important elements that refer to the Christian legacy of the country. One is a reference to the first king of Hungary, Saint Stephen, who made Hungary as part of Christian Europe 1,000 years ago. And the other remark is a recognition of the role of Christianity in preserving nationhood. Well, both statements look at the past. Saint Stephen has lived 1,000 years ago, and the text only says that Europe was a Christian continent 1,000 years ago. To be member of the club, you had to become a Christian. And the reference to Christianity is a fairly utilitarian one. The reference to Christianity says that, well, we recognize Christianity as something that has served the nationhood. It is not a recognition of a religion in itself for the value of itself, but the recognition of the role of Christianity in preserving the nationhood. When you go deeper into the text, we have an interesting article R at the beginning, at the first part of the Constitution. It is an article about the interpretation of the fundamental law. And section 4 of article 4 reads that the protection of the constitutional identity and Christian culture of Hungary shall be an obligation of every organ of the state. The protection of the Christian culture of Hungary. I put the sentence into the chat box. Well, culture is a fruit of faith, and to have a Christian culture, you may need centuries. It took centuries that in a way or another Christianity has fertilized the antiquity for Dante to write the Divine Comedy. It's the first Christians didn't leave behind major artistic artwork or anything like that. It took a long time and a complexity. But what the Constitution protects is not Christianity, it is the Christian culture of Hungary. Christianity is universal, but it is not about Christianity. It is not about the universal Christianity. It's not about Christian faith. It is about the given Christian culture of Hungary, making the assumption that this culture is still Christian by its origin, by its nature, by its nature, I could say. It says in a country where the majority of citizens declare to be Christian, but religiosity and especially churchliness, as sociologists say, is fairly low in Hungary. Well, it's higher certainly than in the Czech Republic. The Czech Republic is more secular than us, but it is definitely significantly lower than in Poland or in Croatia, or even than the religiosity in Slovakia. Maybe 10%, and that's an optimistic percentage, would be a regular churchgoer who would be there at church every week or at least several times a month. Approximately half of the people has a link to the church. The majority of newborn kids are still baptized, but many don't have. When you turn it upside down, you can see that almost half of the kids are not baptized anymore, not even baptized anymore. But still, when we speak in the everyday Hungarian language, then the first name, that is the second name, of course, for us, the first name is usually referred as a Christian name. And people feel offended when, would feel offended if someone would say that, well, you don't have a Christian name, you are not even baptized, and maybe your name is not even a Christian name, it's a pagan name. Some pagan names are very popular in Hungary nowadays. Still, St. Nicholas on the 6th of December is bringing chocolate and candy for all the kids, including Protestants and including agnostics. There is a general culture that is a consequence, that is a fruit of a Christian tradition. But when you imagine this as a kind of a tree, what the Constitution protects is just the fruits of this tree. The tree is bringing fruits of a Christian faith of centuries. But the Constitution has no, or the state in general, has no power in safeguarding the roots of the tree. That is left to the people, and no one else can take over this task, this burden. Does it make sense still to protect this legacy if we are not able, if the state is not able to safeguard its roots, to safeguard the tree itself? The state is just, we could say, interested in the fruits. It is something like the very famous Böckenförde dictum would say that the state that is a secular state nowadays, is depending on preconditions that were not made by it, and the state cannot even uphold these preconditions. These preconditions, the value setting, is set by families, by religious communities, by all kinds of units that society may have, and depends on them. And even a minority, if a minority is a creative minority, then a minority can serve as a yeast, and it can still determine the general culture of a country. Gabriel Garcia Marquez, in his famous novel 100 Years of Solitude, writes about the mythical town of Macondo out in the swamp, and Macondo is hit by a strange disease, a disease where people are losing their memory. They are losing the names and the notion of things. But they try to fight this disease. They try to combat this disease. And pretty much I believe that Europe, or our cultures we are living, is confronted to a similar kind of disease, a disease of losing the meaning of things. And the way village dwellers, if you remember the novel, try to fight this disease is that they label things. They put the names on little tags on things, or give small instructions. This is a cow, it could give you milk, you should milk it twice a day, etc. And they surround themselves with these little memo tags, and they put two bigger tablets. One is written, one is put at the beginning of the road where you enter from the swamp to the village, and they write the name of the village there, Macondo. Well, they shouldn't forget where they live. And they put another major billboard, kind of big sign in the center of the village with the short message, God exists. Maybe a constitution could serve for a generation as such a billboard, as a place of memory, where we can put down the values we believe in, and when we have an endangered consensus, then this endangered consensus can be safeguarded in this way, can be preserved this way, at least for a while. I think this could be part of the vocation a constitution or a state can have, upholding the thesis that the future, the fate, the destiny of it, whether it can be filled with content or not, is depending on many other elements that go beyond the competency of the state. I'm very honored that I could talk at this conference. I'm very curious about the findings of your comparative research. Interestingly, Madl Institute and the Institute of Justice in Warsaw has put two parallel meetings on the same day, and it happens the first time to me that I should be talking on both. And in the Middle Ages, there were some saints who were saint enough to bilocate. I'm not at that level of saintity yet, but I hope that I will have the chance to read the findings of the research done. Thank you for your kind attendance.
Thank you very much, and thank you, Balázs, for your inspiring lecture and the analysis of the relationship between culture and religion and the protection of Christian culture and state neutrality. Before I open the first session, I would like to welcome Professor Szilágyi, who is one of the organizers of today's conference. He is going to deliver the closing speech of the conference. Let me now open the first session, which includes papers dedicated to religious symbols in the public sphere in the legal order of 5 countries: Serbia, Czechia, Croatia, Slovenia, and Slovakia. The first speaker is Professor Dalibor Đukić, who is going to talk about the Serbian legal solutions. Our speaker is an assistant professor of church law at the University of Belgrade in the Faculty of Law, where he obtained his PhD in 2016. He also graduated from Aristotle University of Thessaloniki, Faculty of Theology. His research interests cover topics connected with religious freedom in its individual and institutional dimensions, as well as Serbian legal history. Before I hand over to Professor Đukić, let me remind that according to the program, every speaker has about 15 minutes for his presentation. Professor Đukić, you have the word now.
Thank you, dear Professor Stanic. Good morning, everyone. I will try now to share my screen because I prepared some one presentation that probably will be useful for you and for the audience. I hope that you can see now the presentation on your screens. Thank you again. It is really a special honor and pleasure to participate in today's conference. And I should say that it is always challenging to be the first speaker at the conference, and I really will do my best to present the results of my research. As the most of you already know, those results are the results of the research that I conducted as a member of the research group responsible for the topic freedom of conscience and religion. And that's why I firstly would like to express my gratitude to the Ferenc Madl Institute of Comparative Law from Budapest, Hungary, which is the initiator and coordinator of the Central European Professors Network. The issue of presence of religious symbols is extremely important, and its significance will increase in the future. Professors Toron and Durham from the United States have already noticed in their monography that one of the major areas where the difference between secularity and secularism has been evident in various legal systems around the world is in its attitudes toward religious symbols in public space. This difference between secularism and secularity, secularity as a principle of distinction between church and state, and secularism as a negative conception of separation between church and state, is necessary in order to understand modern church-state relations in general, not only when we are speaking about religious symbols and their use in public space. Religious symbols are present all around us, as you can see, and it could be said that wherever there are people, there is some symbol with religious roots. For the purposes of my research, the term religious symbol has been used for any symbol or all symbols which are linked to or inspired by religion or belief. Also, the meaning of the term public space should be understood in the broadest of the terms. So it includes not only state and public institutions, but all spaces, let's say, outside the private sphere and outside the inner space, inner domain of religious organizations. The use of religious symbols in the public sphere in the legal order of the Republic of Serbia is not regulated in detail. Among the legal regulations that we could mention is the Constitution of the Republic of Serbia and the Law on Churches and the Religious Communities from 2006, and also the Penal Code. But in practice, religious symbols are often present in the public sphere, in public institutions, in public, generally in public, especially in media. And this is a result of informal initiatives and individual expression of religious beliefs, religion or belief. Although there were individual attempts to limit the use of religious symbols in public, they have not received a judicial epilogue, nor has the legislator intervened by amending the existing legislation. I identified several different situations that generate ardent controversies related to the presence of religious symbols in public sphere. The first one is the display in the public sphere of symbols that most of citizens perceive as exclusively religious, like you can see here, icons, crucifix, statues of saints, etc. These symbols are often present in public sphere, public spaces, not only because of their religious meaning, but also because of wider historical identity and cultural significance that they undoubtedly have. The presence of such symbols in public space should not be mandatory, and it is not mandatory, of course, but neither it is feasible to leave it unregulated and open to potential abuses. When we're speaking about abuses, you can see pictures down on this slide where there are people that, let's say, abuse some religious, traditional religious symbols like a cross, star of David's star, and etc. The second, let's say that the law should prescribe the conditions under which the symbols, which have, among other things, a religious dimension, can be used in public space, which bodies decide on that and how their decisions are implemented. This is especially important when talking about public offices, educational institutions, hospitals, but also companies in general. The second is the issue of wearing of religious symbols in public spaces. This is probably the issue that is more important for Western countries at this moment, at least. In the Republic of Serbia, no disputes were arising from wearing religious symbols in or specific clothing that reveals someone's religious beliefs in public. However, this area also should not be legally regulated. Certain religious practices may conflict with applicable law. You can see here the Article 8 of the 2006 Law on Churches that protects the official uniform and all its parts of the priests and generally of clerics and religious officials of any religion. This European practice shows that a certain way of dressing can be prohibited, even if it is a manifestation of faith or belief. Here, the legislator should apply a balanced approach by restricting the wearing of specific clothes of symbols according to the practice of the certain European countries and the European Court of Human Rights, but at the same time leaving space for expressing religious beliefs through religious symbols that do not disrupt the harmonious life of citizens. The third controversy is compatibility of the practice of construction of religious symbols and monuments in public spaces that have been financed by the government, local authorities, or state-owned companies with the principle of secularity and neutrality of the state. In recent years, the practice of building various religious symbols in public areas has been noticeable. It is most often about building cross symbols, chapels, public fountains with decoration that have religious meaning, significance, etc. In academic discourse, such practices are marked as a form of desecularization of public space. However, such facilities do not serve only religious purposes. It is expression of the culture and identity of the vast majority of citizens of the Republic of Serbia. You can see here on the picture the cross in front of outside of one of the cities in central Serbia, and raising this cross that was financed by the local government was the reason for many, let's say, different approaches by academics, but not by any court or any other, let's say, legal method of trying to solve this problem of raising that cross on public land with public money, let's say. The law should regulate the construction of such facilities, taking into account the neutrality of the state and equality of all religious organizations. At the same time, when drafting urban plans, competent authorities should take into account not only religious buildings in the sense of law on churches and religious communities. You can see here the Article 32 of the law that says that churches and religious communities can build on their own temples, other buildings for purposes of service and worship, but here should be added also religious symbols because that is the reason why we have those sometimes those problems, at least in theory. Lastly, but also most importantly, there is a question of whether the manifestation of religion or belief in public space is constitutional, or more precisely, whether religious services and ceremonies that include the use of different religious symbols and have been performed in public or state institutions violate the principle of state secularity. The answer to this question has been formulated by the Constitutional Court of the Republic of Serbia, which assessed that worship in public buildings serves to meet the needs of individuals who use the services of these institutions and does not violate the principle of separation of state and church. It is noticeable that many public institutions do not prescribe in their acts the possibility of performing religious rites at the request of the users of their services. Although those users can refer directly to the law, it would be desirable for internal acts to provide for such a possibility so that a large number of users of services of public institutions would be aware of their rights and how they can exercise them. In the Republic of Serbia, there are no regulations that explicitly prohibit the use of religious symbols. Unlike some European countries, there are no regulations that restrict the right to wear specific clothes or insignia that are related to the religious affiliation of an individual. Since the prohibition in European countries are mostly related to non-Christian religious minorities, one of the reasons for this difference is what we call autochthonous religious pluralism. Churches and religious communities to which the vast majority of believers in the Republic of Serbia belong have existed on its territory for centuries and generally share similar social values and culture. Like in many other jurisdictions, symbols simply are not religious symbols are not a major issue, at least not until the question becomes politicized. This situation could change in the case of settling a large number of migrants on the territory of the Republic of Serbia. Most of them are currently only passing through the Republic of Serbia because they are directed towards their final destination, that is European Union. However, if they remain or settle on the territory of the Republic of Serbia, there will be a need to regulate the use of religious symbols within the field of the state's margin of appreciation in order to achieve a legitimate aim, which is, according to European Court of Human Rights, preservation of conditions of living together as an element of the protection of the rights and freedoms of others. Although no discussion on the use of religious symbols in the public sphere could be heard in Serbian courts, such debates are part of academic and public discourse. The book chapter that I prepared and that will be published in the book that we prepare all together, for the first time will comprehensively and interdisciplinarily deal with the issue of the use of religious symbols in public space in the legal order of in Serbia. And I believe it will be great contribution to the public and academic debate. I hope that I have still enough time just to thank Professor Sobczyk and his assistant Professor Pontiakowski, sorry for the pronunciation, for their efforts to organize this conference. And I hope that I will be able to answer to your questions during the debate, during the discussion, and I will be grateful to hear your thoughts and comments on this issue. Thank you again.
Thank you very much for your paper, Professor Djukic. The discussion, as you know, is planned at the end of the second session of the conference. The next speaker is going to talk about the Czech legal regulations. It is my great pleasure to introduce Professor Damian Nemec, who is the chair of the Department of Church History and Church Law at Polacki University of Olomouc, Cyril and Methodius School of Theology. Among his numerous publications, let me indicate the book entitled Concordat Agreements between the Holy See and the Post-Communist Countries, published by Peters in 2012. Dear Damian, please take the floor.
Thank you very much for the possibility to participate at this conference. And let me excuse me for my imperfectionality in language because the English language is not my preferable one. There are other languages which I know more. I prepared also a short presentation which could be helpful for the participant. And I want to present the concrete regulations regarding the Czech Republic. First, it is important to know that the regulation in this field, in this area, is very recent, only after the collapse of communist regime. The most important document is the Charter of Fundamental Rights and Freedoms of 91, which has been adopted after the split of Czechoslovakia as a constitutive law at the end of 92, because since 1st January 93, the Czechoslovakia split in the Czech Republic and the Slovak one. This charter is very important, especially for case law of the Constitutional Court and also for the whole constitutional system of the Czech Republic, because the constitution of the state doesn't contain regulation of human rights and freedoms. It is regulated exactly with this charter. In this rather short period of time, there is lack of case law, of constitutional law regarding the presence of religious symbols in public sphere. Therefore, it is very difficult to speak about the results of legislation. The legislation has the form of usual law. These acts, these laws, contain mainly restrictions of use of religious symbols based on the possibility of the Charter of Fundamental Rights, because there is written that the practice of religious freedom, of the freedom of conscience and so on, can be limited by laws if it is necessary in democratic society. And now the concrete areas. The first one are the public offices. For this area, there is no legal act which could prohibit the wearing of religious symbols. Only small thing regarding identity documents. According to these laws, these acts, it is not allowed to have covered the head only as an exception because of health or religion. And the bylaws give more regulation in this area. You can see extract from the file from the official website of the Ministry of Interior, which shows which covers of the head are permissible or not. You can see that it is very linked with the growing presence of Islam in the Czech Republic. The first photo is hijab, which is permitted. The second is the niqab, which is not allowed. The third is the neutral cover of head, but it causes shadows in the face, which is inaccessible, excuse my English. And it is in practice very small thing regulated by laws. schools and universities. Until 1989, there were only public schools regulated by the Act of Unified School and the Act on Universities, the Higher Education Act. Since 1990, there are other types of school, differenced in different laws. The Education Act distinguishes public schools, the private schools established by physical or juridical person, and church schools established by a registered church or religious community. The Higher Education Act has other distinction. There are state schools, for example, military or police academy, public schools, for example, the university where I work, and private high schools. In effect, there are no private high school established by any church or religious community in the Czech Republic in the present time. In public schools, it is important for us, there are no legislation regulating the use of religious symbols. For pupils and students, it can be regulated by school rules, but it is not without problems. Therefore, as a reaction on one case law, which I want to present at the end, the Ministry of Education published a communication, you see the long title, in 2014, which in a very modest way suggests that the school rules should abstract from any regulations of religious symbols, or to give the possibility to the director of the school to give an exception because of religious reasons. But we can say that in this area could be summed up the popular saying, less often means more. Workplaces and business activities. It is very important that the kind of work, especially in the sciences and natural sciences, machinery, building of construction of buildings, and so on, is regulated by bylaws of relevant ministries because of the security of work, not because of religious symbols. In trade and services, there is a very different situation. The big shops, for example, Carrefour, Tesco, and so on, have their own dress code, and they give very small possibility to use the religious symbols. The small enterprise, the small shops, don't regulate it, and it is very often very often open to use of religious symbols. When the public offices in the public sphere, state organizations, municipalities, there is usually the dress code which exclude use of big religious symbols because of the religious neutrality of the state. Even more difficult is the situation of teachers in public schools, because they are in three important roles, as you see, employee, formative of pupils, and de facto representative of neutral state. Therefore, the situation of teachers is not so easy, but according to the oral expressions of ombudswoman of the Czech Republic, then ombudswoman, there is just the man successor, only the dress code cannot be the reason for refusal of religious symbols. There should be another more important reason. Media, internet, and social network. It is one of the rare areas where we can find positive regulation, especially for public medias, Czech radio, Czech television, that there it is, according to the laws on these forecastings, it is said that the goal is to provide a balanced range of programs for all sections of the populations, taking into account the freedom of religion or belief, and so on. And the broadcasting should strengthen mutual understanding and tolerance and promote the cohesion of a pluralistic society. It is valid for public media, not for the private media. There is only a negative regulation regarding the advertisement. You can see there are prohibited certain times of advertising. And on the other way, the same law says that the broadcaster may not include religious and aesthetic commercial communication in the broadcast, and it is an obligation for all types of medias. It could be added something more, but I let it for the written version. Another thing which is not reviewed in the list of themes is the Public Religions Assembly. The Act on the Right of Assembly is very young, in 1990, just before the Charter of Fundamental Rights and Freedoms. And for assemblies in public space, there is only obligation of notification towards the municipality, no permission, but these officials can prohibit the assembly because of legal reasons, as you can read. There is an exemption for religious assembly. It is not obligate. There is not the obligation of notification, but it is better to notify it. Therefore, there is a great rate of freedom in the expression of religious belief externally, including use of religious symbol, even including the religious ceremonies, because it was very important during the pandemic of COVID-19. Some parishes, mainly the Catholic ones, organized the worship not in the church, but in the public space, especially in big places, with the notification to the municipality, and a part of this assembly called usually pray for the prayers, pray for the peace. The part of them was the Holy Mass, the Catholic Holy Mass. The only restrictions is that the participants should not have their affairs covered in such a way as to make it difficult or impossible to identify them. And now, the only one case law regarding region symbols. The case began in September or in the year 2013. Two students from abroad, one of Afghanistan, another one from Somalia, both of them Muslim, wanted to become pupils of secondary medical school. And the coming in the school for the Somali girl was connected with incident, and the girl left the school immediately with most emotional expression. In 2014, the case was reported by the ombudswoman. She said that it was an indirect discrimination of this Somali girl. And this girl in 2016 presented the action for the court, but the sentences of the courts are very, very different. First instance said the applicant was not student of the school, she couldn't be therefore discriminated. It was the argument of the school itself. The second instance said the same, but it said also that the conduct of the school was not discrimination, not even the indirect discrimination. There was appeal for cassation for the Supreme Court, but this court said that it is not important if the girl was or was not the pupil, the student of the school. Important is the conduct of the school, and the Supreme Court said it was indirect discriminations because of use of religious symbols. And therefore, the Court of Cassation liquidated the first two sentences and gave this case back to the first instance. The first instance didn't give her sentence because the girl withdrew the action. The school itself wanted that a sentence should be made in the merit of the case. Therefore, it had to be discussed in the second instance, which confirmed the withdrawal of processes. Therefore, the only legal obligated sentence is the sentence of the Supreme Court, which is important and obligated for all lower courts in the Czech Republic. On the other hand, just my predecessor spoke about the politicization. It was very strong in this case. Very important is the position of the President of the Republic, which gave just before the sentence of the Supreme Court the state award to the director of the medical school. As you see, a brave woman in the fight against intolerant ideology for merit for the state. It is one thing which I don't want to comment because it is very difficult to comment it without emotions. The director of the school tried to be elected for the Senate of the Parliament of the Czech Republic in 2020, just after the sentence of Supreme Court. There was 11 candidates. the director was denied according the result of the election, and she obtained only 3.5% of votes. So you can see that the situation of religious symbols in the Czech legislation and case law is just until now, they're unstable and not developed. It is what I wanted to say. I thank for your patience with my language imperfections.
Thank you, Damian, for your analysis of the Czech legal regulations and the relevant case law.